And the issue, frankly, is what's in the case law that we've cited is the level of certainty that you can say as to it came from only one versus, there are similarities. I mean, that's case law talks about just how certain the opinion is permitted and what's the basis for that.
May I address one other matter not related to the weapons? We did file a motion this morning after, and I understand its weight, but so was the discovery they gave us on Friday. I mean, this has been sort of a late game playing both sides. We're not playing games, we didn't wait. But there's a motion pending, it was filed yesterday, to preclude testimony on a question of law. And obviously, we're not asking them to respond to that today since it was filed yesterday, but certainly something we could do tomorrow morning. Or, depending on your ruling on the motive evidence, I mean, simply put, what they're arguing is that there was going to be a hearing on Friday in which he was going to have to produce financial information, which when he got questioned that day by the financial person at the office about the $750,000, that panicked him, that he knew the jig was going to be up on Friday. Well, two things. One, nobody can say what was in his mind. Number two, and as we outline in this memo, Your Honor's tried enough civil cases, and I have too. All you're entitled to on punitive damages is a net worth statement. I mean, God knows as a plaintiff's lawyer, I've asked for much more than that. Never had a judge give me anything more than a net worth statement after a prima facie case of punitive damages was shown. Now, Judge Hall, who would have heard this motion had it gone forward, did hear a motion against the co-defendant, Parker's, where Mr. Tinsley asked for the same thing, and he denied the motion and said, when we get to trial, if you show a prima facie case of punitive damages, then you get it. So the most he could have gotten on Friday was a net worth statement, which wouldn't even come in. Well, first of all, Parker's didn't even have to produce that until trial. What did he do? What did Mr. Murdaugh do in his vocation as a lawyer? He's a plaintiff's lawyer. He and I have talked about this. We never got anything other than net worth statement after there was a prima facie case in front of a jury. So what this motion deals with is excluding sort of opinions of what the law was, or what would be, what would happen in front of the judge, some prediction. Nobody certainly knows what he thought. We have witnesses, I believe, that may testify that he was asked to prepare a net worth statement, which, as you know, and again, one of my complaints as a plaintiff's lawyer, really doesn't give you a lot other than what their net worth is, because that's all the jury can hear on ability to pay, net worth. So if you want to, we think you should allow them perhaps to respond to this in the morning and take that into consideration on your decision on motive evidence. And we'd be happy to argue it in full. I've done a pretty poor job of doing it here right now.
Just in response, Your Honor, they just filed this motion, but it's never been the state's contention that somebody's going to testify and predict what Judge Hall would have done in this particular case. What we can, and there is testimony, and already in state grand jury transcripts, which they've had access to for months and months and months and months, is testimony about the manner in which the plaintiffs in the Boat case were conducting that litigation, what they were expecting, what they had received from the defense, the fact that the defense had claimed that Mr. Murdaugh was broke. They didn't believe it, and so that's what ultimately led to the motion to compel. The motion to compel did not ask for a financial statement. It very clearly asked for identification of bank accounts and other sort of financial information with the intent to subpoena that. That was the motion that was on the table for the very week, just a few days after Maggie and Paul were murdered, on top of the fact that Mr. Murdaugh was confronted the very morning of the murder by his own law firm seeking missing fees. That's the temporal connection of those two events that then tie back to literally a decade of embezzlement that one question begets another, which begets another. To understand why these are significant, the jury has to understand that he had been stealing for over a decade, 99 counts to date, and facing essentially life without parole on these particular financial accounts, and that's the significance of what he was trying to prevent from being exposed. So again, I hear what their motion is, but I think this motion will be moot and ultimately will be resolved during the course of testimony because no one's trying to say what Judge Hall would do. The point is a little different. It's what the plaintiffs were seeking to do and what they had very clearly said to Alec Murdaugh and his attorneys during the course of that litigation.
To get information, they were going to file, and litigated with Mr. Tinsley, very aggressive. He filed a bunch of motions to get financial information, bank accounts he could not have gotten, because you're not entitled to argue about financial ability to pay until you get a prima facie case of punitive damages, and that's what we say here. So he could file whatever he wanted, but to say whether Mr. Murdaugh thought that was a real threat or not, what he thought, and I will tell you that it's not consistent with the state of the law, not consistent with my experience, and I understand, you know, the Attorney General has not litigated a lot of civil cases. I have, since 1986, been trying to get more than just net worth statements in a punitive damages case. Never have gotten it. The last point I'd make is this. His theory, and this is sort of, is that he knew the jig was up, so he went home and blew the head off his son, and butchered his wife. There's not one shred of evidence there was any problems between any of them. There's texts, pictures, people that were with him the previous weekend at a ball game, video from that day with Paul and he having a good time. There is no dispute anywhere that they were the perfect family in terms of their relationships. No divorce, no separated, no left him, no nothing. So this is a fabrication, and they want to use what Mr. Griffin described as bad character evidence. He stole all this money, so he must have killed his wife and son. That is, and as he cited, there are at least 6 South Carolina Supreme Court cases. I may be overstating it. How many? 4?
4.
4 South Carolina Supreme Court cases disallowing, and judges were reversed, disallowing this kind of evidence. Now, if they've got some evidence that Maggie was getting ready to turn them over to the feds, or Paul knew about it, was getting ready to talk about it, or he'd been threatened by them, certainly those cases say that's when that kind of stuff can come in. But not this theoretical, we ain't got a motive, we're going to make one up motive. That isn't.
What I'm getting from you, both of you now, are you give me jury arguments, and you're arguing multiple motions simultaneously. Regarding the motion by the state for me to grant an in limine motion admitting evidence, that's what you're seeking me to do? And you in your motion, you indicate that the basis for this is for judicial economy, that there may be no precedent for the court ruling in advance of any testimony, granting in limine the admission of motive as evidence during the trial. You seeking to have me do that?
Well, Your Honor, I recognize what the court's saying. I think the first issue with that was in response to the defense bill of particulars, and our response to that was they essentially asked. They said, "Tell me what financial evidence you want to go into." And so we responded by saying, "Well, that's not recognized under South Carolina law, but we filed this particular motion."
I understand,
Yes, sir.
I understand all that, but typically a motion in limine is a motion to exclude evidence.
That's correct.
Your motion in limine is for me to admit evidence. And what authority do you have for me to admit evidence through a motion in limine?
Well, and of course, in our motion, and stand by for me, Your Honor, just one second. So ultimately, I recognize that typically a motion in limine is to exclude evidence, but the cases that we cite and the language we cite in our motion, of course, is, you know, to prevent disclosure of potentially prejudicial matter to the jury, and of course is strictly conditional and subject to the actual evidence being offered. And so the point was to, because it's very extensive and because we realize that this case is different. As I've argued, this case is much different than any case we've ever seen because of the complexity of all these factors going together. And I think essentially what we were trying to do is at least get some sort of preliminary guidance, understanding that evidence will have to be developed at trial as to the admissibility of this. Now, ultimately, if the court is more comfortable with having in-camera proceedings as to the admissibility of evidence, then I understand that, and we can do that as the case develops, as we were talking about the other things.
Complains that, well, this will create a mini trial, given all of the various offenses, 90-something allegations. And of course, we also deal with the issue of res gestae, issues of matters that may be too remote in time, and the like. What I'm grappling with is your request for me to grant the in limine the admission of evidence. I frown upon motions in limine, period, because I don't know the facts. I do not know the facts in this case. I know what you all have submitted in your briefs, your arguments, and whatever you say is the case, the defense says the opposite. That's why we have testimony, and judges are to rule not based on lawyers' arguments, but based on evidence. And I am not prepared to grant in limine a motion admitting evidence, though it may be admissible under the same theories that you have promoted. I agree with the authority and the rule that allows for motive to be admitted in a case under appropriate circumstances. And your all's argument in the cases cited by the defense, some are remotely similar in facts, and most of them are dissimilar. Each case must be decided on its own facts and circumstances. I believe that the Siegel case is persuasive authority, U.S. v. Siegel, though in that case, very noted jurist who spent some time in our state was reversed by one of our noted jurists, Judge Traxler, on the same issue. But I'm not prepared to grant admitting evidence in limine. It must be done during the course of the presentation of the evidence during the trial.
I absolutely understand that, Your Honor. And again, I recognize that we were attempting to perhaps identify those issues and bring those issues because of the complexity of everything to the court's attention. And I certainly understand and recognize, and that's the typical manner in which we would do that, is to have those issues addressed as we move through the trial.
That deals with that issue.
Thank you, Your Honor.
That leaves a ballistics issue.
Your Honor, I believe at this time we can move to that. I'm going to turn the presentation of evidence over to Mr. Fernandez, who will call Mr. Greer.
Thank you, Your Honor. May it please the court. State will call Paul Greer.
For the record, spell your last name.
My name is Paul Greer, Greer.
with whom you're currently employed?
I'm employed at the South Carolina Law Enforcement Division, which is commonly known as SLED.
All right, Mr. Greer, for purposes of this council hearing, would you please just describe for the court your educational background and qualifications in the area of firearms identification?
Yes, sir. I received a Bachelor's of Science in Biological Sciences from the University of South Carolina. At the completion of my collegiate career, I began an internship at SLED in the Firearm and Tool Mart Department. I was appointed as a firearms examiner, a forensic scientist in the laboratory in 2014, where I began the SLED Firearm and Tool Mart course of instruction. This is an extensive training program that's conducted under the supervision of other court-qualified examiners. During that time, in an extensive period, I conducted many written and practical examinations, conducted many microscopic comparisons, and assisted other examiners prep their cases. At the conclusion of my training, I was then given a comprehensive final exam that included mock casework and was able to begin casework on my own after successfully completing that.
Thank you. And Mr. Greer, would you please describe for us the field of, broad overview is fine for purposes of today's hearing, but an overview of what firearms identification is and the expertise that you've developed?
Yes, sir. Firearms identification is a discipline of forensic science in which our main objective is to examine fired ammunition components in order to determine if they were fired by a specific firearm.
And are you a member of any organizations, or have you obtained any additional trainings or certifications as it relates to firearms identification?
Yes, sir. I am a member of the Association of Firearm and Tool Mart Examiners, which is also known as AFTI. I've been a member of that organization since approximately 2015. AFTI is an international organization that I believe has approximately 1,200 members of folks in the field who do firearms identification and tool mark identification. This also includes technical leaders from the academic world and also from other aspects.
Thank you. And if you would, please describe the process that you go through and the training that you go through in order to become a forensic firearms and tool examiner at SLED.
Sure. That refers back to that course of instruction that I completed, that approximately 3-year or so program, and where I conducted all the microscopic comparisons, looked at things on the microscope, test fired firearms, observed cartridge cases that were fired out of the same firearm, cartridge cases that were fired out of different firearms, bullets as well. Learning about firearms, manufacturing process of those firearms, and how that relates to the range of conclusions that we issue as firearms examiners. During that time, I also completed those written and practical tests. Some of those tests include studies that have been conducted throughout the United States and worldwide to include consecutively manufactured bullets and cartridge cases. I've completed those, successfully passed those. At the end of my training, I was given that final exam and also some mock casework in which I was able to complete and successfully pass.
Thank you. And have you had a chance, I know you mentioned you're part of the AFTI organization, AFTE. Have you had an opportunity to attend additional conferences and trainings that they would put on an annual basis?
Yes, sir, I have. When I'm able or training is available, I attend their annual conference. That is a large conference where materials presented about new technologies in the field or updates, new procedures that may be coming in order to do things or arrive with different items. But I attend those conferences when able. I also participate in other training as necessary, such as our Glock Armor certification when I'm able to do that. AFTI also has other things they provide. Webinars, if I'm able to participate in those, I will take part in that.
And in order to become a firearm and tool examiner with SLED, are you given certifications and tests that must be passed, both competency tests and proficiency tests?
Yes, sir. A part of our quality control at SLED, SLED, the laboratory is accredited by ANAB, which is the ANSI National Accreditation Board. That follows the standards set forth by ISO 17025, which is an international accrediting set of standards. And we follow that, and within that we have a SLED quality control manual that requires before we're able to participate or be authorized to perform work. We are competency tested and deemed competent to do that. Also, in addition, each year we are proficiency tested to make sure that we are maintaining our competency.
Okay. Mr. Greer, specifically relating to the purpose for which you were called today, in describing the area of firearms identification, would you please tell the court a little bit about the methodology that goes into that, and whether that methodology has been subjected to both being, published in journals or subjected to peer review? Would you please talk about that whole process and the culture?
Sure. Firearms identification has been around for years. During that time, there's been many studies that have proven the reliability of firearms identification. Those studies are published in articles through AFTI, such as the AFTI Journal. Those studies using a scientific method are published in the AFTI Journal, or Journal of Forensic Sciences would be another one that could be included. And those are peer-reviewed. Those are looked at by members of the academia or firearms identification, other examiners. Those are reviewed and those are published in those two journals for sure.
Do you know what year AFTI was founded, for how long this organization has been around?
I believe AFTI was founded in 1969.
All right. And discussing the methodology of peer review, you indicated that the journals, that the information that's published in journals, that's in fact subject to peer review, meaning other people in the field or folks in the scientific community are able to review it and analyze it. Is that your understanding of it?
Yes, sir. That's my understanding. They would be able to review the article as it's presented prior to publication, review what has taken place in that article or that experiment, and share their thoughts with that process. Those articles are then, peer-reviewed and issued in those journals.
These articles are not only information, but it's also sometimes and frequently an examination of some study that was performed. Is that your understanding of these articles and review of those articles?
That's correct.
In addition to the methodology and peer review publications in your field, could you please discuss the specifics of that peer review process and methodologies in SLED in particular?
Sure. As part of our quality control process at SLED, again, we are accredited by ANAB. We just received our reaccreditation. We're accredited every 4 years during that cycle, and we just received our reaccreditation. And that again follows the ISO 17025 standards. We also, on top of that, have the SLED quality manual, which we follow closely to make sure that we're adhering to those procedures. And as part of that, we have a firearms departmental manual that gives us guidance in how to perform our actual casework, how to perform our examinations with the evidence. In that process, in that quality control peer review, our casework at SLED is 100% micro-verified. And that means that another qualified examiner will look at the evidence, arrive at their conclusions, and agree or disagree with me. For those to be reported, that examiner, we will, if he or she agrees with my results, those will then be reported. The case file itself also undergoes a technical administrative review process as part of the quality control and peer review procedures.
And as part of your in-house peer review, is that a blind review that is performed?
Yes, sir, that is.
And speaking of the organization, the accreditation organization, ANAB, is that an international organization?
The ANAB is in the United States, but they follow the international standards set forth by ISO.
Thank you. And then the second layer would be, so SLED itself, the organization, the law enforcement agency SLED is accredited by ANAB.
The Forensic Services Laboratory is.
And then beyond that, SLED Forensics has a quality assurance manual which is followed by your lab. Is that correct?
That's correct.
And then beyond that, the SLED's firearm department has its own manual. Is that correct?
That is also correct.
All right. Has the field of firearms identification been applied in previous similar situations?
Yes, sir.
Okay. Well, let's start with sort of the big picture, the broad picture. Where and how is it typically applied? This field of study.
Firearms identification has been around for years. Since the early 1900s, we have been evolving on firearms identification.
And it's used in court cases across the world. Is that correct?
Yes, sir, that's correct.
Specifically relating to your personal experience, have you been sworn as an expert in firearms identification in previous court cases?
Yes, sir, I have.
And providing live testimony for a trial?
Yes, sir.
And approximately how many cases was that?
I've testified in state and federal courts approximately 25 times.
Certified or firearms identification examiners have been utilized in, as far as you're aware, per your organizations, have been utilized in court cases across the globe. Is that your understanding?
Yes, sir.
I know you mentioned that this field of study has been around since the early 1900s. Does this applied science use the scientific method when applying, your information you gather and then your opinion that you render?
Yes, sir. It does follow a scientific method and approach in order to conduct our examinations.
All right. Could you please describe what the scientific method is as applied to this forensic field?
Sure. As far as applying a scientific approach, when we conduct our examinations or we're looking at firearms in the scientific method, one thing when we're working a case or if you're looking at it in this manner, you may ask, you form a hypothesis, are these cartridge cases fired by this firearm? So that would be our hypothesis. We would evaluate the conditions under that, do research, and then we would actually do experiment. In this case, in this example, what we would do is test fire that firearm using similar ammunition that we're comparing it to. We would determine our conclusions and arrive at those conclusions. Then that can be also applied to casework. If I receive a case, look at all the evidence, look at the characteristics on that, examine the firearm, test fire that firearm. I've already compared those cartridge cases to each other and determined that the characteristics of that firearm can be compared to those cartridge cases, compare that, determine a conclusion. In order to determine, and then our peer review process kicks in order to determine whether that is reproducible or the repeatability of that scientific procedure. That's where our peer review process would come in. Another qualified examiner would come in and look at that, and if he arrives at the same conclusion, then that method has been deemed repeatable and reliable.
Thank you. In the 25 times that you've testified in both state and federal court, has your testimony been ruled admissible, meaning you could render your opinion to the jury?
Yes, sir, it has.
And were any limitations placed on your testimony in the 25 times you've appeared?
There were none.
All right. The field of this forensic field of firearms identification, could you please describe the quality control? I know you have mentioned some, but could you please describe the quality control procedures that are in place governing this body of work?
make sure that we're complying with our own policies and as well as theirs. As far as internally, we also complete internal audits each year where other departments will audit and make sure that there's compliance within each department.
And although redundant, please describe to us the SLED quality control manual that's followed in the laboratory.
Yes, sir.
Could you describe it? What essentially is it, and how do you follow it?
Yes, sir. The SLED Quality Control Manual follows those standards that are given by ANAB. It follows that so that way the SLED laboratory has strict guidelines in which we follow in order to make sure that we stay in line with our accreditation procedures and policies.
And if you would, again, although I know you explained it previously, but please describe the firearms department manual that's followed.
Yes, sir. The firearms manual is a set of procedures that we follow as examiners in order to give us instruction and information on how to complete our examinations, how to handle firearms-related evidence and tool mart-related evidence. It also includes some terminology that we use within our case files. It gives us guidance to make sure that we are all operating consistently and within those guidelines of the quality control procedures.
And if you would also please describe the code of ethics that is applied to yourself and your colleagues within the laboratory.
Yes, sir. Each employee at the SLED laboratory, including myself, signs a code of ethics that we must abide by each year, and that is a code of ethics for the workplace in our forensic laboratory, and that is recorded within our quality control procedures.
An additional quality control procedure would be the micro-verification process. Please briefly describe that for us again.
Yes, sir. Before a conclusion is rendered via report, each examiner will examine the evidence, arrive at a conclusion, write those conclusions down. At that point, another court-qualified examiner will examine the evidence and arrive separately at their conclusions to create a blind verification. If those conclusions are the same, then the reviewing examiner will sign off on those conclusions so that a report can be drafted. As also part of that process, the entire case file and report are reviewed for a technical review and administrative review before the report is released.
And in order to become a forensic examiner with SLED, is that person required to pass a competency test?
Yes, sir, that is correct.
And you in fact passed that competency test?
Yes, sir.
And are there also proficiency tests that are required each year?
Yes, sir. We do take a proficiency test within our discipline each year.
All right. Please, we're going to talk a little bit about, but I'd like you to describe how the area of firearms identification is consistent with recognized scientific laws and scientific procedures. So I think you mentioned before, but is firearms identification, do you all operate under the general rubric of the scientific method?
Yes, sir.
And again, describe the scientific method and how it relates, maybe how it applies to the firearms identification, beginning with essentially a hypothesis or a hypothesis, and then proceeding along to where it becomes a theory. Could you please describe that process?
Yes, sir. You would look at your evidence, or in this case, if you're just doing an experiment, and try and determine a hypothesis. Are these cartridge cases fired by this gun, or are these bullets fired by this gun? You would do the research to determine what materials you may need. In this case, you may use like ammunition that you're trying to compare to. You would examine those characteristics to make sure that the comparison should be completed. At that point, you would begin your experiment. In this case, you would test fire the firearm. You would compare those cartridge cases from the firearm with each other, and also with those cartridge cases or bullets that are questioned, and arrive at conclusions. At that point, you would conclude your experiment, issue your conclusions, and open up for any discussion. That is similar to casework in the fact that's a very similar method as what we use there. For repeatability and reproducibility of that, at that point, that experiment could be passed off to others in the field of firearms identification or in academia to review and comment. They could use the evidence or the cartridge cases and conduct their own experiment with it and see if they arrived at those same conclusions. If they do, then that theory has been proven and considered reproducible and reliable.
And generally speaking, in the applied sciences, is it important that the test be as accurate as possible? The test you're trying to reproduce in the lab.
Yes, sir.
Is it important that it's reliable, meaning you can rely on the procedures that you're implementing and the results you're trying to obtain?
Yes, sir.
And is it important that it's repeatable, meaning you could repeat that same process, or your peer review colleague could repeat the same process? That's an important component of this examination.
Yes, sir. That would be an important component of the scientific process.
In addition to all the scientific method and the processes you just described, again, this field of study, this applied science, is it also published in journals and academia for peer review?
Yes, sir, it is.
And are you familiar with some of the literature out there, having reviewed it yourself?
Yes, sir.
Thank you, course indulgence. All right, Mr. Greer, thank you for answering my questions. I do have a couple other areas I'd like to ask you about, specifically relating to some of the criticisms that was referenced in council's motion, specifically 2 National Academy Sciences reports and the what's been referred to as the PCAS report. Are you familiar with those 3 areas?
Yes, sir, I am.
Okay, great. I'd like to ask you, let's just go in chronological order if that works for you. Beginning with the first National Academy of Sciences report in 2008. I believe it was, well, tell me are you familiar with that study?
Yes, sir, I am.
Do you recall generally what the study related to, the title or the area, field that they explored?
The 2008 article from the NAS was an article by a group of researchers dealing with ballistic imaging.
If you would, and you have familiarized yourself with that report, is that correct?
I am familiar with it.
What are some of the... All right, well, Your Honor, at this point, before we go into the reports, having established a foundation for his expertise, we do request that Mr. Greer be admitted as an expert for purposes of the rest of this testimony in the field of firearms examination.
Before the defense proceeds with, you have some questions for him? You have voir dire for this witness?
Not on his qualifications, Your Honor. For purposes of this hearing, that he is certified, I believe, under AFTE. That I don't have any questions on his qualifications.
All right, he's so qualified.
Shifting back then, Mr. Greer, to the first NAS, National Academy of Sciences report. The test was conducted on ballistic imaging technology, and was it critical towards that field? The general gist of it?
Yes, sir. Your Honor, may I refer to my notes?
Yes, sir. We'll take about a 2-minute break.
Right.
Okay, you may proceed.
Thank you. Mr. Greer, I believe we were referring to the 2008 National Academies Report.
Yes, sir.
All right, could you please outline some of the criticisms that were raised by that report?
That report brought into question some of the reproducibility of firearm-related tool marks and whether the additional research of the reproducibility of those firearm and tool marks should be done.
And as it's stated, what was the primary focus, or what area was that focus of this 2008 report?
The primary focus of that research, or the reproducibility of the the tool marks from firearms, was conducted through the ballistic imaging software. It did not take into the account of the human, such as I, an examiner working on a microscope, looking at that with my eyes. It was all in the ballistic imaging software.
We're going to get into some of the opinions you might have on the report, but in general, is it fair to say that the report focused on the technological component of things and declined to take into account perhaps a full picture?
Yes, sir. I believe it failed to take into the account of the human in the process, looking at it with their physical, with their eyes on a physical microscope.
In written vacuum, if one were to simply read the 2008 report without any context or understanding of the firearms identification field in general, do you agree that it was a fair or accurate reflection of your field?
I feel that it could have included more of the human interaction with the examination process, more in line with what I am accustomed to doing at the SLED laboratory.
Do you feel that it was an accurate reflection of what examiners do and the skills that they obtain and utilize?
An examiner goes through a rigorous training process, extensive research during their training, looking at many microscopic comparisons, and whether or not they're issuing articles throughout their career to be peer-reviewed in those journals, they are doing research in that training process, comparing known items to each other and known non-matches, looking at the difference in those. And I feel that this article, if it didn't take into that account of that human interaction, looking at that, the ballistic imaging technology may not have accounted for that.
And just in how many do you know, or roughly how many exams or examinations or analyses have you performed in the field of firearms identification?
At this point in my career, I would say thousands of comparisons.
All right, and concerning still on this 2008 report, was there some, did the issues of the report have to amend or issue corrections on the report in certain instances?
The 2008 report was not intended to cause any issues with the admissibility of the firearm and tool mark evidence in its admissibility. There was a statement from Dr. John Rolfe, who was a member of the study, who had to address some of that information, and that the NAS report did not mean to cause that situation to occur.
All right, thank you, Mr. Greer. Shifting focus to the second NAS, we're calling it the NAS report, that was performed in 2009. Are you familiar with that report?
Yes, sir, I am.
And have you had an opportunity to review it prior to today?
I am familiar with the report.
All right, describe to us, if you would, what the nature or the substance of that report was focused on, the area that it was focused on.
The report was generated, and it made 13 recommendations regarding forensic science. 6 of those recommendations related directly towards fireman toolmark or AFTI, and those are the recommendations that I'm more familiar with.
Okay. So, and just to be clear, while the report issued 13 total recommendations, 6 would apply to your applied science field of firearms identification.
Yes, sir. 6 of those directly relate to that.
Thank you. All right, if you would, let's walk through, of those 6, let's walk through what the recommendation was, and then I'd like you to address your analysis of that and what your agency does, you know, as a response to that. So, beginning with the first recommendation, was there a recommendation to establish standard terminology?
Yes, sir, there was.
Okay, and in general, that's what the NAS report kind of touched on. What is, how does SLED operate with all the certifications we've understood? How does SLED operate as far as terminology?
Yes, sir. At SLED, we as firearms examiners utilize the AFTI glossary, which is a book of terms related to fireman toolmark identification. That glossary is used by examiners all over the world, as AFTI, again, is an international organization. And that glossary has been available since, I believe, 1980. So it's constantly been updated as needed, new terms included. But we've always had that glossary and to refer to. In addition, at SLED we have certain procedures that we follow to use certain terminology or abbreviations that standardize our reporting or case file documentation.
What would be the second recommendation that the 2009 report issued that would relate to your field?
The second recommendation dealt with establishing quantifiable measures due to the reliability and accuracy of the forensic analysis.
Okay. And if you would, just explain generally what that means, what the recommendation was.
Basically, what they recommended was that the reliability and accuracy of the forensic techniques should reflect the practice on case scenarios. They should establish the limits of reliability and accuracy and using those analytical methods that can be expected to achieve when looking at, to achieve as the conditions of forensic evidence vary. There's been many articles published throughout the history of fireman toolmark identification that address the reliability and accuracy of our field. Ever since it really became popular in the early 1900s, they used that scientific approach, and since then they've built upon that hundreds of articles discussing fireman toolmark identification, comparing those fire cartridge cases, those bullets, those ammunition components, and determining the reliability. There's studies that address that and using different scenarios and also help to provide some insight as to the reliability of it.
And does SLED, the two situations you've mentioned, the scientific method and that approach, as well as the studies, articles, and peer review, are those two areas that SLED has already incorporated into its field of study?
Yes, sir. Part of our peer review is part of our process in order to complete a case at SLED.
All right. If you would, please describe the third recommendation from the 2009 report.
The third recommendation was basically to, in summary, what they wanted was to establish protocols for forensics examinations, methods, and practices.
All right. And how does SLED already address those recommendations?
Yes, sir. Again, we have those protocols set in place in our firearms manual, in which we are able to follow to guide us through our examinations. We also fall under those accrediting bodies of ANOB and ISO 17025 that guide us in accordance with those international standards. And that's how we've met that standard, and we've been fulfilling that.
And for purpose of just brevity and economy, all the protocols and standards we've established previously, that would apply to this recommendation. Is that fair to say?
Yes, sir. In my opinion.
What would be the fourth recommendation from the 2009 report?
One of the highlights from the fourth recommendation was laboratory accreditation. And individual certification of forensic science professionals should be mandatory, and all forensic science professionals should have access to the certification. Certification requirements should include examination, supervised practice, proficiency testing, continuing education, and adherence to a code of ethics, as well as other things. But that's a quick summary of that recommendation.
All right, and would you please explain how SLED operates within that recommendation?
Again, the accreditation process, as we were just reaccredited. Also, after going through the extensive training program, we are competency tested. We're giving those extensive practicals and terminology tests and essay questions to complete. We're given those competency tests to include the casework that represents an array of the type of cases that we'll be working on. We have to complete those and successfully pass that. We're also proficiency tested each year. Each examiner is proficiency tested in order to maintain and prove that you're maintaining your competency. And we attend continuing education as we are able to by participating in webinars, attending the annual conference of AFTI, and so on. And also the Code of Ethics, we sign that each year as employees in the Forensic Services Laboratory.
All right, please describe, if you would, Mr. Greer, the fifth recommendation from that report.
Yes, sir. The fifth recommendation was forensic laboratories should establish a routine quality assurance and quality control procedures to ensure the accuracy of forensic analysis in the work of forensic practitioners.
And describe how SLED already operates under that suggestion recommendation.
Yes, sir. Again, the accreditation with ANAB, ISO 1705, adhering to that SLED quality manual, the peer review process that our casework undergoes to make sure that it's all reviewed 100% before issuing those conclusions and those reports.
And finally, the sixth recommendation from that report. Would you please describe what it is and how SLED already operates under it?
Yes, sir. That was the Code of Ethics. The National Institute of Forensic Science, with its advisory board, should establish a national code of ethics for forensic science disciplines. And we have the code of ethics that we sign to guide us through for forensics in the workplace.
All right, thank you, Mr. Greer. The final study that was referenced in council's motion is called the PCAST, P-C-A-S-T report, which was done in about 2015, 2016. Are you familiar with that report?
Yes, sir.
All right, could you please tell us a little bit about that report, kind of overview of what essentially it was and what some of the findings were?
Yes, sir. The PCAST report was a report that was issued by the President's Council of Advisors on Science and Technology. They issued the report entitled Forensic Science in Criminal Courts, Ensuring Scientific Validity of Feature Comparison Methods. Basically, this report, and I apologize, challenged us as firearms examiners in a few different methods with some of the things that they recommended for firearms or found issue with in the field of firearm and tool mark identification. I apologize. One of the issues that they noted was that firearms analysis falls short of the criteria for foundational validity because there's only a single appropriately designed study to measure the reliability of firearm and tool mark analysis. The other was that they had issue with with those studies and how they were designed. Another issue was brought forth to firearm and tool market examiner. Excuse me. Were the methods in which we arrive at our conclusions. That is to include the subjective and objective measures that we take to arrive at those conclusions.
Have there been criticisms of the PCAST report?
Yes, sir. There have been some criticism of that report.
Have you reviewed some of the criticisms of that report?
I have.
Do you share do you agree with the criticisms that you've reviewed?
I am familiar with some of those criticisms, and I do, as an examiner, agree with the responses by some of our scientific groups in firearm and tool market examiner.
Could you share some of the criticisms that called the validity of that report into question since its publication?
Yes, sir. Part of the one of the things with the PCAST report is the group of researchers who compiled that report. None of those researchers had any firearms identification experience. I believe, in referencing some articles, that none of those had even worked in a forensics laboratory, and only 2 had claimed that have any backgrounds in forensics. So none of those people who compiled that and issued those statements about firearm and tool mark identification even claimed to have ever been in a forensics laboratory. So that is one issue. As what we do is very specific, and we undergo lots of years of training to arrive at becoming a competent examiner.
Has AFTI, the organization you're a member of, have they rendered criticisms and responses to the PCAST report?
Yes, sir, they have.
Okay. And are you also familiar with the organization OSAC?
Yes, sir, I am familiar with that.
What is that organization?
The OSAC is the organization, of scientific area committees. That is part of a committee that each forensics discipline has a group in, and that is a committee that's within NIST, which is a federal scientific organization.
You mentioned the committee NIST, that's NIST,
Yes, sir.
and that's the National Institute of Standards and Technology.
Yes, sir, I believe so.
And is your understanding that that's a federal organization as well?
Yes, sir.
So OSAC is under the umbrella of the NIST organization?
Yes, sir, that's correct.
Beg the court's indulgence. That's all the questions I have, Your Honor. Certainly happy to hand over to defense counsel. Mr. Greer, thank you.
Mr. Griffin?
Good afternoon, Mr. Greer. Good afternoon. Or Agent Greer, I apologize. You mentioned that you had been qualified to testify as an expert in some 25 cases, courtrooms like this?
Yes, sir, I have.
And in this case, isn't it true that there is no weapon that you were able to test to see whether these, well, let me strike that. You were able to test a weapon of a .300 blackout type to see if that weapon, shell casings and other, I guess the bullet, if you will, projectile matched what was found at the crime scene. Is that right?
Yes, sir, I did receive fired cartridge cases and projectiles to compare to a rifle.
And you used the methodology of the AFTE to perform the test. Is that fair?
Yes, sir, and also our SLED firearm department manual, which is a document that I would follow to conduct those examinations.
And I believe that in that 300 blackout that you used was found in the gun room at the House of Moselle. Were you aware of that?
I am not sure the location. I would have to check the submission paperwork to the laboratory.
In any event, you were provided a firearm, item 33, I think, in your report, and you test fired it and compared it with what you provided that indicated it came from the scene. Is that right?
Yes, sir. May I refer to my report?
Oh, sure, absolutely.
Your Honor.
Your Honor, what was marked one court's exhibit for Your Honor?
I gave it to him, so no objection.
Thank you. And it is attached to our motion. And so, Agent Greer, I believe you have identified item 33 in your report as one Palmetto State Armory model PA-15 semi-automatic rifle, 300 blackout caliber. Is that correct?
Yes, sir.
And in your report, it said that this rifle was test fired using the item 34 magazine, and during the test firing, the first available cartridge in the magazine was fed and chambered correctly, and that then you test fired and extracted and ejected from the rifle. How were you able to, I guess, exclude, or maybe your result was inconclusive, that item 33 did not fire did not extract and eject the spent cartridges found at the scene? And your analysis is in item 128 of your report.
As far as the cartridge cases from the scene, which items are you referring to?
Well, the ones that were seized from the scene are items 2 through 7?
Okay. Yes, sir. The results of the comparisons of items 2 through 7 in my report, when I compared those with each other in test cartridge cases that I fired from that item 33 rifle, the results of those comparisons were inconclusive. That means I am unable to determine whether those items were fired by item 33 or by another firearm with similar characteristics.
And then you also, as my understanding, you matched up spent shell casings, items 2 through 7, with other spent shell cartridges or casings, specifically items 35 through 37, 39, 108, 113, 116, and 17, and 122. And then you concluded, what did you conclude with regard to that analysis?
Yes, sir. I concluded that matching individual identifying characteristics were found in the mechanism marks of items 2 through 7, 35 through 37, 39, 108, 113, 116 through 117, and 122 to conclude that those items had been loaded into, extracted, and ejected from the same firearm at some previous time.
Now, is it clear that you did not have the firearm that that your opinion is was used to extract and eject those cartridges?
I am able to determine that those cartridge cases had matching mechanism marks listed there, but in comparisons with the item 33 rifle, I'm unable to determine if they had been fired by that rifle or not.
Okay, but let me ask you, what's your opinion with regard to the spent shell cartridges, items 2 through 7, with the other spent shell cartridges you identified?
Which cartridge cases are you referring to?
17 and 122.
It's my opinion that those all had
From one firearm at a previous time, I mean, can you do it without firing the bullet? Is that what you're saying?
Yes, sir. The cycling marks sometimes could occur just from cycling through the firearm. For instance, if you were to load a cartridge into a magazine, or cartridges into a magazine, load that magazine into a firearm, and chamber that unfired cartridge into the chamber of the gun so it's in battery, ready to fire. If you decide not to fire that weapon, you may, in this case it was a rifle, pull back on that bolt handle. In that case, in that instance, the unfired cartridge would be extracted from the chamber of that gun and ejected. There can be marks left on an unfired cartridge due to that process without having firing the cartridge.
So what level of certainty do you have as to the fact that, in your opinion, that items 2 through 7 were loaded into, extracted, and ejected from the same firearm at some previous time as items 35 through 37, 39, 108, 113, 116 through 17, and 122? What's your level of certainty?
That is my conclusion. After I examined the evidence, I arrived at that conclusion based on the years of extensive training, looking at thousands of comparisons, and basing that conclusion upon that. If I thought it could have been a different answer, it could have been inconclusive, but I was able to determine that the agreement that I saw on those items was sufficient enough to determine that they had been cycled through the same firearm at some previous time.
Do you hold that opinion with a reasonable degree of scientific certainty?
It's my opinion that those had matching mechanism marks.
Well, they have matching mechanism marks, but are you able to state with a reasonable degree of scientific certainty that only one weapon in the entire universe would have produced those matching marks?
Based on all of the markings and tool marks and cartridge case and fire bullets that I've looked at in my career, I have examined and conducted thousands of comparisons. I've participated in studies and competencies in which I look at things to determine if they were fired by a particular firearm, and able to build a foundation in which I can base my opinion. And it's my opinion that based on that training, based on those studies I participated in, some of those included consecutively rifle barrels, consecutively manufactured slides, and I've successfully passed those, that based on the information there, after I examined those cartridge cases for those markings, it's my opinion that those items all had shared matching mechanism marks and had been loaded into, extracted, or ejected from the same firearm at some previous time.
Are you aware of any studies that have ever been done on a 300 blackout?
300 blackout is a newer caliber. I'm not aware at this point in time. I'm sure there may have been research, but I do not have research with me today on cartridge cases of that caliber.
Are you familiar with how a 300 blackout is manufactured?
With basic manufacturing processes, yes, sir, I suppose so.
Right, and so, and in fact, you know, some company or gunsmith will assemble a 300 blackout from component parts using the various component parts that are mass produced. Is that correct?
Are we talking about component parts of the rifle?
Yes, sir.
Different manufacturers choose to make their parts, or they can have those supplied by other vendors. Yes, sir, I suppose so.
Do you know how the 300, well, do you know how any of the 300 blackouts that Mr. Murdaugh purchased for his son Paul were manufactured, where they were purchased, how they were assembled?
I do not have information as to how they were purchased or assembled.
Okay. Are you familiar with production lots? How, say, rifle barrels are produced in a production lot, mass production?
Yes, sir.
Okay, and are you familiar with any studies that have concluded that projectiles fired through rifle barrels produced in the same production lot have identical markings?
I am familiar with certain studies. Some of those I participated in as part of my training that are known around the United States and internationally. That consisted of those consecutively rifle barrels. That means that they were made by a tool at the same approximate time in the same state of wear. I've also done those studies with cartridge cases, looking at the consecutively manufactured breech faces. And we as firearms examiners are aware of those markings. And in those studies, they're conducted because in the fireman tool mark identification world, if you will, if we are expecting to see those carryover of those markings, we would expect to see that on tools that are made, or excuse me, on barrels that are rifled consecutively, or those breech faces that are manufactured consecutively, because that's when that tool is passing over that surface one after another. And I've conducted those studies, such as the Beringa 10 barrel test, the Hamby breech face test, the Glock Ebus barrels, which all have consecutively manufactured items within them. And I was able to distinguish between those items and looking at them under the microscope, evaluating those characteristics that are exhibited on those fired components, and correctly identify and associate those with the correct information.
And there we're talking about I guess, what do you call the inside of the barrel of a pistol or rifle, correct?
Yes, sir, that would be the bore of the barrel.
The bore of the barrel. Are you familiar with any studies with regard to what you relied upon here, which would be extractor and ejector marks?
Yes, sir. There are studies that have shown the reproducibility of those markings, and how firearms examiners were able to distinguish between those manufactured components.
And are you familiar with any studies of the component parts that were used in 300 blackouts?
I'm sorry, can you repeat the question?
Are you familiar with any studies that were done on the extractor and ejector component parts that are used in a 300 blackout assembly?
I don't have any information with me today in regards to the 300 blackout, but all those components are machined in similar ways. They all have similar manufacturing processes, and I've demonstrated throughout my training that I was able to distinguish between those consecutively manufactured parts. So just because it may be in a 300 blackout, if I may have done that in something similar, such as in those tests with the Ruger pistol or the Glock pistol, and was able to distinguish, even though they may share similar manufacturing techniques. I don't have an article with me here today in regards specific to that caliber, but based on my knowledge of the manufacturing process in fireman tool mark identification, I would expect to be able to rely on that information as being reliable to examine that caliber.
Now, as I understand it, you examined the, I guess, spent cartridges and under microscope, and you compared items 2 through 7 with the others to conclude they matched. Is that correct?
I was able to say that Items 2 through 7 had the matching mechanism marks.
Now, what matching mechanism marks are you referring to?
Those would be marks that are from the ejector or extractor. That could include the chamber marks or lug marks that we see on that type caliber ammunition.
And are those the only marks that you saw that matched?
Based on my examination, those are the marks that I was able to conclude that matched. When I looked at the totality of that cartridge, that fire cartridge case, excuse me, to look at the firing pin or breech face marks, I was unable to determine that if it was fired by the item 33 rifle or by another rifle that was similar.
I understand. The mechanisms that you say matched, how many points did you conclude matched in order to reach your opinion that there was in fact a match?
I'm sorry, I don't understand the question.
When you compare tool marks, how many specific markings on an item do you need to find that match in order to say that it's a match?
Yes, sir. At SLED, we use a process of pattern matching. So in that pattern matching, we are comparing the surface contours of those tool marks to each other. Pattern matching is the worldwide accepted method for fireman tool mark identification. So we're in line with other laboratories, in forensic laboratories with fireman tool mark identification, to conduct those comparisons using that pattern matching method.
And how many marks make up a pattern? That's SLED.
There's not a policy for counting those lines, as we rely on the pattern matching method, which is accepted throughout our field.
So you determine whether it's a pattern, or is there a standard that you go to measure to say, oh, there's this, this, and this, so it meets the definition of a pattern?
Based on all my training experience, looking at those thousands of comparisons, looking at items in which I know match, looking at the agreement that's seen there between those two items, looking at items together that I know are known non-matches, looking at any agreement that may be there, of course we would expect to see some disagreement, and evaluating those characteristics throughout the course of my training, looking at all of those. I use that to base my opinion on that in regards to those items 2 through 7, that they had matching mechanism marks.
So do I understand you correctly that there's no standard that you rely upon to determine whether a pattern exists?
I use the pattern matching method based on the extensive comparisons that I've conducted, looking at the literature, participating in those studies, in order to determine that I can evaluate the difference between the different characteristics that are exhibited on the items, as well as the quality control procedures at SLED that help to ensure that we're issuing a quality product in our results.
So you know it when you see it, but does someone review above you to cross-check to say whether he or she agrees with your pattern analysis? Does that exist at SLED?
Yes, sir, absolutely. Every case that we work at SLED to issue a conclusion is 100% micro-verified. So that means I look at the evidence, I examine it under the comparison microscope, look at all of those characteristics and features, and arrive at my conclusions, whether things I'm able to identify or I say are inconclusive or even eliminate. I come up with those conclusions and write those conclusions down. It's at that time that another court-qualified examiner comes behind and reviews the evidence as well. They look at all the evidence on the microscope, compare those features as I have, independently, and arrive at their own conclusions. If he or she agrees with my conclusions, they're able to sign off on those conclusions, and the process of issuing that report is continued. So that's part of our quality control process that each case undergoes. And another component of that is once he or she agrees or disagrees with that conclusion, the report will undergo a technical administrative review as well as the case file. to ensure that quality product.
Does the reviewer, the he or she who reviews it, your work, know of your conclusions before they review?
No, sir. We have a blind verification process, so they do not know our results.
And who reviewed your work and the analysis in this case, that's Court's Exhibit Number 1?
The reviewer for this case was Chad Smith.
Does his name appear on this report that I'm overlooking?
His name would not appear on the report, as I'm the one issuing the report. His name would be included in the case file documenting his agreement with my conclusions.
Okay. And you're saying Mr. Smith would not have available to him your conclusions before he looked at the shell casings here?
That's correct.
Now, can you say, well, let me ask you, have you ever rendered an opinion in court that you have here today that just looking at spent shell casings without having a firearm to test that they came from the same firearm?
I believe I have, yes, sir.
You more than once?
I'm unable to recall about how many reports I've issued based on those cycling marks. I believe I have issued a report like that in the past, where I was able to look at those cartridge cases, and I don't remember the details of the case, whether there was a gun involved or not.
So I'm asking, actually testified in a court of law, not just issuing a report. Do you recall ever offering testimony in a court of law that you have here today, that just looking at spent shell casings on tool mechanisms, that you've concluded they were fired from the same weapon?
I've testified in court approximately 25 times regarding my conclusions. In regards just to, if you're discussing mechanism marks, I would have to recall and check a file. I don't know off the top of my head. But I have testified in court approximately 25 times to my conclusions that I've issued in a report in regards to firearm and tool mark identification.
And earlier you were talking about reports. How many times do you think you've ever issued a report where you concluded, just based upon your analysis of the spent shell cartridges, that the cartridges were loaded and extracted from the same weapon at some previous time?
I don't have that number with me today.
Is this an uncommon conclusion, or is this something you do fairly regularly?
It's not uncommon. Our ultimate goal in firearms is to identify or eliminate. And in this case, I was unable to identify several of those cartridge cases, as I have that inconclusive result. But in looking at the information, those characteristics on that cartridge, on those cartridge cases, I was able to determine that conclusion and look at those markings and the totality of those areas around the cartridge case to say that those items had been cycled through the firearm at some time. Can
you said you were unable to match the spent shell casings with item 33, is that correct?
Yes, sir. Item 33 was the rifle.
And that was the rifle provided to you. Were you aware that that rifle was purchased about the same time as another rifle for son Paul, and that was stolen?
I don't know the history of these rifles or how they were recovered or obtained.
Can you, is there any way for you to tell what year rifle you're referring to in your report, where you say there's matching mechanism marks that were loaded into and extracted from the same firearm? Can you tell that was a 2017 300 or 18, 19, 20?
No, sir. I'm not able to date the firearm.
Okay. Now, you were asked about the various criticisms by the NAS, and that's the National Academy of Science, is that correct?
Yes, sir, that's correct.
And the criticisms in your field, and they were specifically criticizing the organization to which you adhere to, the Association of Firearm and Tool Mark Examiners, correct?
Our organization issued a response to those articles. Yes, sir.
Okay, and you said that that SLED continued on, and you know, and did they make any adjustments? Of course, this was before you became the 2009 report was issued before you started at SLED in your capacity. Is that correct?
Yes, sir. I was hired on at SLED in 2014, so I'm unaware of the past of what may have been completed, and I was signed off to conduct firearms examinations in approximately 2017, I believe.
And then there was the report issued by the President's Council of Advisors on Science and Technology in 2016, and you testified about that, correct?
Yes, sir.
And I think you cited to the language that we've included that the firearm analysis field still falls short of scientific criteria for foundational validity. Is that right? That's their criticism?
Yes, sir. I believe that was their criticism.
And one of the specific criticisms was that the AFTE's theory of identification that two tool marks have a common origin when their firearms are in sufficient agreement is circular. That the AFTE declares that an examiner may state that two tool marks have a common origin when their features are in sufficient agreement, and that then defines sufficient agreement as occurring when the examiner considers it a practical impossibility that the tool marks have different origins. Isn't that what you have done in this case?
I have applied the AFTE theory of identification to my identification process. However, that AFTE theory, as presented by the PCAS, doesn't take into effect the full entire theory. They make it seem that circular way when in fact the sufficient agreement threshold that we're looking for as examiners is exhibited, again, when we are looking at those items and those tool marks, so that the amount of agreement is greater than our best known matches that we've ever seen in literature, in our studies, based on peer review, in other methods, that the agreement is greater than what's seen in the best known non-matches in a consistent agreement with what's seen in known matches. And to help us arrive at that, we're looking at the significance of that. We're looking at the individual peaks and ridges and furrows of those tool marks and those surface contours. We're looking at the relationship of those lines to each other from tool mark to tool mark and how they compare with each other, looking at the width and the depth and the curvature of those lines in order to determine and help us in our process of identification. So there's a little more to the theory than maybe what was presented by the PCAS report.
Another criticism that we've cited is that your field relies on training and experience and uniqueness in lieu of empirical demonstration of accuracy. And isn't that what happened here? You use your training and experience, and there's no objective standard for measuring against whether there's a pattern or not. Is that fair?
We do use our training and experience. That is correct. We rely on those years of looking at those comparisons and conducting those examinations and building up that process to an identification. It's important, I think, to know that firearm and tool mark identification is maybe an applied science, something kind of like medicine or engineering, where there's a lot of book work that may be involved, but a lot of the learning may be more hands-on, and it may require training to become proficient, kind of like a residency for a physician. There's nowhere where you can just learn to do this and start tomorrow. There's a lot of training that goes on, hands-on training, and then looking at that, much like those other disciplines, like an engineer or a physician who they don't just finish school, they have to go through a process to learn and help hone their skill. And during that time, it helps us to learn and understand the differences in those microscopic comparisons between tool marks.
So would you agree that there's somewhat of an art to your field?
Yes, sir. There could be can be considered that way. As an applied science, there is a little bit of an art to what we do. We use different lighting to look at these marks. We look at these items, these projectiles, these fire cartridge cases at different angles in order to look at them all on a comparison microscope, where we're able to see under high magnification the details within these tool marks, those individual peaks and ridges and furrows, in order to base our identification on. All while there are some objective standards that we're meeting in order to get to that point of an identification. We use measurements of the items, looking at it, counting lands and grooves, to make sure that as we're going up in our identification process, we're kind of like climbing a ladder. Certain characteristics have to agree in order to continue on that process to an identification. So in short, firearms, the identification portion is subjective in nature, but it's based on the applied science and some objectivity that we're able to derive in order to determine those conclusions.
Two other questions for you. One, if you have the opportunity between now and when you testify, will you research to see if you can find any studies where 300 blackout tool marks have been tested to determine whether one 300 blackout produces tool mechanisms unique to every other 300 blackout in the world? Would you mind doing that?
Yes, sir. I will look into the literature. Again, based on firearm tool mark identification, there's been hundreds and hundreds of studies throughout the years that demonstrate the reliability of our field and produce those error rates to help us go by that we can fall under. And so, knowing the machining and manufacturing process of some of those components, we can't possibly look at every firearm in the world to compare that to. However, knowing how those guns are machined and taking that information and applying it to the different components and different firearms, those techniques would carry over based on the literature that's been proven. Yes, sir.
I'm asking about 300 blackouts, but if you want to do AR-15s, that's okay.
Yes, sir.
And then, if you don't mind checking your files to see how many times you've issued reports where you just have shell casings and you've concluded that one single weapon was responsible for extracting and ejecting the shell casings.
Yes, sir. I'll see if I can gather that information.
Thank you.
Let me redirect.
Nothing from the state, Your Honor.
All right, thank you, sir.
Thank you.
Any further witnesses on this issue?
None from the state unless we need a rebuttal witness.
Anything from the defense?
No, Your Honor.
Any argument?
Yes, sir, Your Honor. I believe from Mr. Greer's testimony, Agent Greer's testimony, he's more than established the various factors in the counsel test. I'd like to start with factor 2, and that has been previously applied in similar situations. And again, Agent Greer testified that, of course, firearm and tool mark examination has been done in thousands and thousands and thousands, probably millions of cases all over the world since the turn of the past century, the 19th century. So I think that factor is very well established. The next factor, of course, is the methodology has been published and subject to peer review. You've heard testimony and, of course, the general experience in the courts of how that there have been plenty of studies done and subjected them to peer review. You heard about many studies that have been done in various journals, including the Journal of Forensic Sciences. You've heard about the accreditation process, which also goes into factor 3, which is quality control procedures. That includes a very rigorous accreditation from A&AB and that sort of thing, which also requires peer review. Then you've heard about the specific quality control procedures that dedicated sled where they have a specific set of procedures that must be used in order for these tests to be conducted. Finally, you of course heard at SLED about blind review by another examiner who looks at those without knowing the original examiner's conclusions, who then peer reviews those particular results and determines whether or not, or it comes to the same conclusions, or if not, then obviously there's a problem, and there's not any such problem here. If we look at the particular qualifications of Mr. Greer and just generally firearms and tool marks in general, he talked about the fact that they have to go through competency tests and proficiency tests. And one of the things that he talked about, if you look at whether or not something's repeatable or reproducible, which goes to factor one, which of course is the scientific methodology, is he talked about participating in consecutive rifling studies. And so why that's important, Your Honor, is that's the ultimate test of the reliability of this technique, because you have firearms that have been consecutively manufactured, meaning that there has not been that much time for there to be wear with the manufactured components between those various barrels. And the test to the examiner, the study to the examiner, is can you still distinguish even though those rifle barrels were made one after another? And you heard Agent Greer testify that he participated in those studies and various ones, and he was able to successfully distinguish between the various barrels even though they were consecutively manufactured. That's obviously excellent evidence of the reliability of the methodology and its consistency with recognized laws and procedures. This is an applied science, but you heard Agent Greer, it's a highly recognized one, it's one of long standing, and you heard Agent Greer testify that it's much like medicine and engineering. The fact that it's an applied science does not make it not a science. Agent Greer testified in great detail about much of the criticisms that were in the NAS report and the PCAS report that are cited in the defense motion. And he identified, going through, for example, with the NAS report, one of the things that he pointed out was that there was a lot of criticism about that report. And Your Honor, in our brief, which I know we filed this morning in response to the defense motion from yesterday, so I don't know if you've had a chance to review it, but we've cited case after case after case that identify the problems and the refutations of that report. But you heard from him the problem with that report was that it was using ballistic imaging software and that there was a lot of criticism as to its findings there, to the point where one of the authors of the report, Dr. I'm sorry if I don't remember his name, but you heard testimony from Agent Greer about that he actually issued a refutation saying, hey, we didn't mean for this report to undermine or challenge the admissibility of firearms and tool marks identification. So that addresses the NAS report. With the PCAS report, there were 6 recommendations that specifically related to tool marks and firearms identification. And you've heard from Agent Greer about how those various recommendations were either already addressed or have been addressed, and how there's continued studies about the accuracy, such as the consecutive barrel test and all the rest of it. And additionally, you heard from Agent Greer that in looking at the criticisms of the PCAS report, which again, if you look at the cases we've cited, has been rejected by the FBI, it's been rejected by the Attorney General of the United States, as well as the Association of Firearms and Tool Examiners, for a number of reasons, but some of the ones you just heard testimony about, including his opinion that those criticisms were valid, were that none of the people involved in that had firearms and tool examination experience, that most of them, or if not all of them, had never even worked in a forensic lab. And of course, ultimately, you heard that they did not take into account the full theory of identification, which is the basis for this particular science. There was certainly some cross-examination about 300 blackout and that sort of thing, but you heard from Agent Greer that 300 blackout is the ammunition is made from common components. And with he mentioned also the AR-15. We are talking about matching whether or not a particular round was cycled through a weapon. Well, the receivers in these weapons, again, there's a standard component processor to that. So there still is recognized studies there, and it doesn't change the fact that 300 blackout is manufactured from commonly made components, much like 223 or other rounds. There's nothing fundamentally different about that. Your Honor, if you look at all those various factors for the council hearing, I believe that they're all established in a great degree. And I think ultimately what we've heard today is the fundamental aspect of weight and non-admissibility. Certainly the defense can cross-examine, they can raise these issues, they can raise criticisms of the science, but it's been more than established we would submit for admissibility into this trial. Thank you, Your Honor.
By the defense.
Yes, Your Honor. The standard for admissibility of expert opinion is the expert has to hold the opinion with the reasonable degree of scientific certainty, whatever the field is. Mr. Greer, Agent Greer, was unable to testify. He would not testify that he held his opinion to a reasonable degree of certainty. And he had to concede that there are no studies to support his opinion that even AR-15 or 300 blackout, the mechanisms that he relied upon, that they were uniqueness. And so those are, you know, the case law that we rely upon, you know, addresses that, particularly when it gets to the level of certainty of the expert to say it came from this particular weapon. The cases that we cited in our brief reject that. I know there's some contrary law cited by the state, but the basis of his opinion here is simply his experience, as explained by Mr. Waters, of testing rifle bores and handgun bores. And we are not talking about markings on a projectile that went through a rifle or handgun bore. We're talking about ejector marks from when a bullet or shell casing is ejected from a weapon. And that is a bridge too far. Thank you.
I find that the state has met the requirement of admissibility under Rules 702 and 703 of the South Carolina Rules of Evidence, as well as under State v. Counsel. I find that the evidence proposed will assist the jury in understanding an issue in the case. The witness is well qualified and that the underlying science is reliable. The matters at issue involving this witness will be matters for cross-examination and for the jury to determine its weight. Though the witness did not state that specifically that he holds this opinion to the reasonable degree of scientific certainty, our courts have thoroughly held in numerous cases that there are no magic words that are necessary for an understanding as to the opinion and the level of certainty that a witness has in offering an opinion. So the witness was firm in his opinion based on his years of experience and training, and I find that the findings indicated in State's Court's Exhibit Number 1 is admissible.
Thank you, Your Honor.
Your Honor, can we ask that the state produce the reviewer's report if it exists? The expert testified that there was a blind review and that it matched his, and we would ask that it would fall under Rule 5 as results of a test.
Says the state.
Your Honor, we've produced the entire case notes and case file. I will double check with the agents, and if there's something else, we're certainly happy to make that available.
Well, the witness said that it would be indicated in the reviewer's report. I think he said that, and so.
I think it should be in the case notes that have already been provided, but we will double check, and if there's something that hadn't been provided, I would be surprised if that's the case, but we'll certainly rectify that if that's the case.
All right. Anything else today?
Nothing from the state, Your Honor.
Nothing, Your Honor. We would like to discuss the schedule for in the morning, logistics. If-
Okay. You all right? Go right ahead.
So do we need to be here before 11?
Well, the jury is due in at 11. Any other matters do you all want to take up before 11?
I think we've resolved everything right now. Now, this is obviously a big trial and a fluid situation, but I would say that we could show up for selection. I'm not aware of anything right now that we need to address, Your Honor.
Sir?
I'm not aware of anything right now that we need to address prior to the jury appearing.
I don't think we have anything to deal with before 11 o'clock tomorrow morning.
All right. When the jury arrives at 11, the clerk will have to go through this process of scanning them in order to compile a list for us. I'm not sure how long that process will take. How long do you think it will?
We've asked them to be here about 10:45,
Okay.
so if that happens, we should be ready to go by 11.
Okay. She said that if the jurors are timely in getting here by 10:45, as she requests them, they should have them scanned and the list prepared by 11. So we'll see you all tomorrow at 11. Court will be in recess until 11 tomorrow.